If one of your loved ones becomes incapacitated, you may need to file a petition to be appointed as the conservator in order to legally manage their affairs. You're already thinking that I may need to sell their house in order to cover the cost of their care. How does that work? Hello again, this is Certified Probate Real Estate Specialist Daryl Williams with Win-Win Realtors here in Southern California. On this program, we assist personal representatives and probate attorneys with estate real property. So if you find this program informative, educational, and entertaining, be sure to like, share, and subscribe. Let's get started. Let's start by looking at the parties in a conservatorship. There is the conservatee, that is the person subject to the conservatorship. There is the conservator, that is the person who has petitioned the court to be appointed over the conservatorship. There is the private investigator, that is a person who has been appointed by the probate court to investigate the case. There is the probate referee. That person's job is to appraise all of the property in the estate. As I mentioned earlier, these aren't all of the parties, but these are the main parties in a conservatorship. When a decision has been made by the conservator that there is a need to sell the conservatee's house, the conservator files a petition with the probate court explaining why selling the house would be in the best interest of the estate. Selling a house in a conservatorship is similar to selling a house in a probate administration. The sale has to conform to the probate laws and local practices. Here are some important factors to know when selling or buying a property that's in a conservatorship. There is a disclosure exemption. Since the owner of the property is deceased and cannot disclose any known defects, conservatorship properties are sold in their as-is condition with no warranties and no contingencies. Also, conservatorship properties must be sold at least for 90% of their appraised value. A conservator can be granted full administrative powers where they can accept the offer on that conservatorship property and no court confirmation would be needed. However, if there is an objection to that offer from any interested parties, court confirmation would be necessary. A hearing date would be scheduled, and at that hearing date, the property will be subject to other bids. If there is an acceptable bid, that property will be sold to the highest bidder, and the highest bidder will have to deposit 10% via cashier's checks the day of the hearing. Question of the day: have you been a conservator in a conservatorship? If so, did you have to sell the conservatorship real property? Let us know in the comments below. Another option that a conservator may consider opposed to selling the conservatorship real property is renting or leasing the property out, which will also require permission from the probate court. I'm Daryl Williams. This is Win-Win Realtors TV. If you have any questions for me, don't hesitate to contact me. My contact information is in the description. This program is for information purposes only. It is not legal advice. I am not an attorney. If you need an attorney, please contact one. If you need an estate planning attorney here in the state of California, Southern California in particular, feel free to contact me for a referral.